I'm not sure, if you want to comment on veterans in politics, the corruption, I guess that's a gray area.
Good morning, I'm Mitchell Langberg for the moving defendants.
Controller for the plaintiffs.
Okay, I've got defendants motion to dismiss under NRCP 12B. I've got special motion to dismiss, anti-SLAPP motion. And I've got the motion for reconsideration of order granting ex parte motion to enlarge term to serve. Okay, let's make, I'm going to deny the motion for reconsideration. Okay.
Yes, Your Honor.
I'll address the motions to dismiss the anti-SLAPP and the.
I'm cognizant of the time and the calendar, Your Honor. And we worked very hard to extensively brief. And I don't want to regurgitate what's in our briefs. So I'm going to focus briefly on the anti-SLAPP motion and reserve most of my time for rebuttal because there's a lot of issues covered. To simply state that under Nevada Supreme Court authority, it's pretty clear that we meet the first prong as far as the issues were made in the statements that are alleged were made in a public forum and they were on a public issue. And we've met the burden, the very low burden, frankly, that the Nevada Supreme Court has for demonstrating that they were made either truthful, but more importantly, made without knowledge of falsity. And so that automatically shifts the burden to the plaintiff to show that his claim is legally tenable and factually supported by competent, admissible evidence. They didn't even try to do that. So that's the end. So I can talk in detail, Your Honor, about the legal issues on the statute of limitations, whether the statement's fact or non-fact, all of those issues. But once you conclude that we've met the first prong of the analysis, they didn't even try to meet their burden on the second prong. There's no need to talk about those extensively. I'm happy to respond to questions or to what counsel states.
Okay.
Thank you.
Hold on just one moment. I want to take a look at something. Both of your motions were filed on the same day, right?
Yes, Your Honor.
Okay. So if I were to, what's your contention relative to the order in which these motions should be ruled on?
Fair question, Your Honor. I think based on the legislative intent and the context of the statute, the anti-SLAPP statute, that should be ruled on first, or at least together, because the legislature has made a conscious decision that when First Amendment rights are implicated by a claim, such as are here, that its goal is to quickly determine to quickly identify meritless lawsuits, dismiss them, and have the defendant pay the attorney's fees. So that legislative intent, the entire purpose behind it, would be undercut if one were to rule on the 12B motion and decide that the anti-SLAPP motion was therefore moot.
Okay. Hold on just a second here. Let's see.
Yes, Your Honor.
The pleading to which your motions are directed is the amended complaint.
Yes, Your Honor.
First amended complaint.
Yes, Your Honor.
And I'm taking a look at the allegations here just a second. Okay, that's fine.
Okay.
I'm here from the
Thank you, Your Honor.
Plaintiffs' Counsel.
I'll keep it brief as well. I understand you've accommodated us to hear all these at the same time, and we appreciate that. I don't believe that allegation is correct. They have to prove that there is a statement of public concern that is truthful or without knowledge of falsity. I'm not sure, if you want to comment on veterans in politics, the corruption, I guess that's a gray area, but people can have an opinion on that. Saying that someone is a rapist and a woman beater is not an opinion. That is a statement of fact that it has no basis. There's been no, even the affidavits attached there to the motions to dismiss don't give a factual basis. We've cited cases that say that even in the context of someone in the Coker case selling lithographs online, that he claimed that at the time he thought they were true without any legitimate basis for that, they still ruled that was a untruthful statement, or there was no demonstration of a good faith basis for the statements. So if we're talking about the anti-SLAPP, they
And I think Mr. Sanson himself has in the past made anti-SLAPP motions, right?
correct.
In other cases.
And that's true, and we acknowledge that. But the issue here, it comes to the substance of what's being claimed here and the ongoing damages, and we can touch on the statute of limitations. We've made our argument on that in the pleadings, and the court's either going to accept those or they're not. And if we're wrong, we're wrong. But when we're talking about specifically the anti-SLAPP issue, especially with legislative intent, the legislator was not intending to protect falsely alleging someone beat their wife or is a rapist. The legislative intent was not to bring that into a public forum and protect that speech. That is not protected First Amendment speech. I'll admit that the corruption issue that they claim with Barron's politics, that could be more of a gray area, but there are statements here directed against my client, Steve Sanson, that have no factual basis and no demonstrated basis within the affidavits attached thereto that would give rise to that. So we don't believe they get to go as far as getting into what they're getting to. The first step is it truthful? Is it truthful, or is there a basis for which they could have believed it to be true? And there's no statement of even where that information came from, just that it's what they heard, so they automatically believed it to be true. I don't believe that that's protected by the anti-SLAPP statute, but I'll answer any questions the court has. But as counsel put it, this has been thoroughly briefed on both sides.
I'll be even more brief than before, Your Honor. They misunderstand the first step because the Supreme Court has made clear, Mirza and Four Star and other cases, that a defendant merely giving a declaration that says they believe the statements to be true, if they were matters of fact rather than opinion, without contrary evidence provided by the plaintiff, is enough. Supreme Court has said that expressly multiple times. This notion of rapist, there's only one allegation in the entire complaint that deals with spousal abuse, and it says that Sanson published something about spousal abuse. It doesn't identify any of the parties, so that doesn't go to any of the defendants that I'm appearing for. Each of the statements that is alleged to have been made by one of the defendants that I'm appearing for, which is Ms. Abrams, Shones, and Cicero, I think is the pronunciation. Each of those statements have been addressed, and declarations address why they're either statements of opinion, or even if the court thought they were statements of fact, why they believe them to be true, which meets the standard that the Supreme Court has repeatedly set. If you have no further questions, Your Honor, I have none.
So you've addressed both motions, right?
Excuse me?
You addressed both motions.
Yeah, well, I've addressed the anti-SLAPP motion. I think I don't have anything to supplement our papers on the 12B motion, unless you have questions.
Okay, no. Counsel, did you address both motions as well?
Yes, sir.
No, okay.
Unless you had any other.
No, it's well briefed. I'll review it further and issue my ruling. Okay?
Thank you.
Thank you, Your Honor.
And to refresh my recollection, is there a deadline by which I have to make this ruling?
Yes, there is a statute provides. I don't know. I would be lying if I told. I would be guessing if I told you, but the statute does have a number in it. I can look it up, Your Honor.
I thought it was 45 days, but I'm not totally sure either, to be honest, Judge.
You said what?
I thought it was 45 days, but I'm not.
Okay, I'll do it as soon as I can. Okay.
Thank you, Your Honor.
Thank you.
Thank you.